Hi, I'm Sibyl Winchester, and this is Legal in 60 Seconds, where I break down real estate legal questions and hot topics in under a minute. This week's question is why homestead status matters in a Texas real estate transaction. In Texas, homestead status is not just a tax concept. It is a constitutional protection that plays a critical role in real estate transactions. Under the Texas Constitution, a homestead cannot be sold or encumbered without the consent of the owner and the owner's spouse. A common misconception is that the spouse is required to sign closing documents because of Texas community property laws. While community property rules can apply, homestead law is often the real reason a spouse's signature is required. These are two separate legal concepts, even though they sometimes overlap at closing. For example, if a property was acquired before marriage, it is generally considered separate property. However, if the spouses live in the property as their primary residence, it becomes their homestead. In that situation, the non-owner spouse must still sign the deed, not to claim ownership, but to formally consent to the sale of the homestead as required by the Texas Constitution. If the property was acquired during the marriage, Texas law presumes it's community property. In that case, both spouses must sign as owners. If they also occupy the property as their homestead, both signatures are required for that reason as well. This is where community property and homestead laws overlap. Finally, for non-homestead investment property, a title company may allow closing without the spouse signing the deed, provided the spouse signs a non-homestead affidavit. Understanding homestead status early helps realtors avoid closing delays, contract issues, and last-minute surprises. There you have it. Let us know what you like answered next.